Tonight on Insights on PBS Hawaii. In 1993, the Hawaii State Supreme Court seemed to pave the way for same-sex marriage. But 20 years later, we continue to debate this issue while legally permitting the compromise of civil unions. How far have we come in the past 20 years? And where are we headed in Hawaii and across the country? Now, live in our studio, our host, Dan Boylan.
Aloha and welcome to Insights on PBS Hawaii. I'm Dan Boylan. This week we mark the 20th anniversary of Bear versus Lewin, a Hawaii Supreme Court decision regarded as a landmark in the long debate over the constitutional and civil right to gay marriage. The controversy over same-sex marriage has raged over the last 20 years as states around the country have passed laws to legalize or outlaw it. 2 years ago, Hawaii passed a law permitting civil unions that extended to same-sex couples many legal benefits of marriage. This year, state lawmakers chose not to advance competing bills introduced to legalize gay marriage or reserve marriage for opposite-sex couples. Same-sex marriages generate strong opinions, and we'd like to hear yours, plus your questions during the next hour. Do you wish state lawmakers would have taken some action this session, or are you satisfied with the civil unions law? How will our state and country ever reach any kind of consensus on this issue? You can join our conversation by calling, emailing, or tweeting your questions and comments for our guests. The contact information you now see on your screen will be repeated throughout the program. Insights is also streaming live on your computer right now and will be posted on our website following this program. Like our broadcast, the streamed version is closed caption. Now to our guests. Stephen Levinson retired from the Hawaii Supreme Court in 2008 after serving as an associate justice for 16 years. He was appointed to the First Circuit Court and then to the State Supreme Court by Governor John Hawai'i. In his second year on the High Court, Justice Levinson wrote the Bear versus Lewin decision that we will review in a moment. James Hochberg is an attorney in private practice. He is local counsel for Alliance Defending Freedom in a current case known as Jackson versus Abercrombie, which he will explain in a couple of more moments. Jim is also president of Hawaii Family Advocates and pro bono attorney for the Hawaii Family Forum. Renea Stewart has been with her partner Lisa for 19 years. They declined to get a civil union after civil unions became legal in Hawaii last year and continue to wait for an opportunity to marry in Hawaii. Renea is an Emmy-nominated documentary filmmaker specializing in Pacific Island-themed programs. Glenn Stanton is Director of Family Formation Studies with Focus on the Family, a national organization based in Colorado that provides Christian-centered guidance for families. He is also a research fellow at the Institute of Marriage and Family. Glenn has authored a number of books and travels the country, speaking on issues of gender, sexuality, marriage, and parenting. I think there's a song that starts 20 years ago today or something like that. I don't know if this was the day, but Justice Levinson, you were there. You wrote the opinion in Bear versus Lewin, and we've been talking about it, it seems to me, ever since in some way or another. Give us a little history of how we got to that decision and where we went immediately after.
Well, actually, it was 20 years ago Sunday. Cinco de Mayo was the date on which the opinion was filed. Although it was argued the year before in September 1992. 3 couples in Hawaii wanted to get married, and that was unusual only in that each couple was a same-sex couple. They were refused marriage license applications and sued the director of the Department of Health, the Department of Health having jurisdiction over the issuance of marriage licenses in Hawaii, for refusing to grant them the licenses and permit them to marry. They argued that the Hawaii marriage laws were unconstitutional under the Hawaii Constitution insofar as they discriminated against them as same-sex couples and therefore violated the state constitution's right to the equal protection of the laws and also the right to the due process of law. The case didn't get very far at the circuit court level. The plaintiffs filed their complaint. The defendant answered. The defendant filed a motion in the trial court for what's called judgment on the pleadings, and the court granted the motion, basically ruling that given the facts that the plaintiffs alleged in their complaint, there was no conceivable theory under which they could prevail ultimately at trial. The plaintiffs appealed to the Hawaii Supreme Court, and in May of 1993, the court held in a package of opinions, but the lead opinion held that which I wrote, that the Hawaii marriage laws presumptively violated the state's Equal Protection Clause insofar as that provision expressly prohibited discrimination on the basis of sex, and that the state therefore bore the burden of demonstrating a compelling interest in that sex discrimination, which it would have to meet at trial. And so we vacated the circuit court's order and judgment in favor of Director Lewin, remanded the matter to the circuit court for trial, and it ultimately went to trial in 1996.
But that opinion also, the first holding that you had was that there is no fundamental right to same-sex marriage in Hawaii under the right to privacy or otherwise. And then you moved over to the benefits under the Equal Protection Clause. Am I remembering it correctly?
Well, we took one claim at a time. There was not a plurality on the panel that heard the appeal that was persuaded by the plaintiff's privacy due process argument. And so we found that there was no fundamental constitutional right of same-sex marriage to be found in the state constitution's due process clause. So then we moved to the equal protection claim, and we found that there was a colorable equal protection claim, and that the state would have to demonstrate a compelling interest in the discrimination that was plain on the face of the statute, and the state failed to do it. I mean, when the matter finally went to trial in 1996, it was really a battle of the experts. There were very few facts. None were in dispute. The parties stipulated to them. The plaintiff had two expert witnesses. The defense had two expert witnesses. The issue at trial, the state's claim of a compelling interest in the sex discrimination was that child rearing ultimately takes place in a nuclear family setting with one mom and one dad. Ultimately, on cross-examination, Director Lewin's experts crumbled. They conceded that there wasn't any research demonstrating that same-sex couples were any less effective at parenting than opposite-sex couples. And the trial court, Circuit Court Judge Kevin Chang, wrote an extensive decision with findings of fact, conclusions of law, and a judgment finding that the state had failed to meet its burden. And therefore, the plaintiffs prevailed, and the state's marriage laws were deemed unconstitutional. He stayed his judgment pending a second appeal to our court.
Renea, you were probably only about 12 years old then, but do you remember this case when the decision came down?
Yeah, I actually do.
And you remember your reaction to it?
At the time, I mean, I was so impressed with what Justice Levinson had done, and actually, I mean, it was just such a pivotal moment in our country's history, with today Rhode Island becoming the 10th state to actually stand on the right side of justice
on this day, not on Sunday, but
for marriage equality. So I think it speaks volumes to where we've come from. What I was really surprised at is how this state, enacted the ban, right after Justice did so much great work. What surprised me the most
it was actually 4 years later, if I'm not mistaken, that the constitutional amendment was adopted.
Right, for the ban. But, I mean,
or 5 years.
But nothing happened in between where we were granted marriage equality.
Right.
So the reason it surprised me so much is because my partner was born and raised in Hawaii, and that's obviously one of the reasons that I moved to Hawaii. Besides the aloha spirit of the state, besides the wonderful Hawaiian culture, I was really impressed how progressive this state has always been. You take leaders like Patsy T. Mink with Title IX and women's rights issues, and it just was really disappointing to see that there wasn't more acceptance.
Jim, you were around then. What was your reaction when Bear versus Lewin came down?
I was a much younger man.
Yes, of course, as we all were. But
well, I think as I read the opinion, I thought it was very interesting that there is no fundamental right to same-sex marriage in the state of Hawaii under the right to privacy or otherwise is the phrasing, but that we would have to deal with withholding benefits which violates equal protection. Because back then, the conversation in the public square shifted to benefits. And in connection with the constitutional amendment that went through the legislature in 96, 97, the Reciprocal Beneficiaries Act also came through, which gave people who couldn't marry, because actually marriage equality is not happening in Rhode Island. Because same-sex couples can marry and heterosexual couples can marry, there's still restrictions on marriage. So marriage equality is kind of a misnomer. Marriage equality would say dads can marry their daughters and brothers can marry their sisters because there's marriage equality. So I take a little bit of, I don't know, it's not really marriage equality that we're talking about. But and I actually filed an amicus brief in the Bear v. Lewin case with the Rutherford Institute. It was about this thick. Back then, the AIDS medical research on the LexisNexis medical site was just publishing tons and tons of stuff about AIDS. And we were arguing that that's a compelling reason to not support same-sex marriage. I don't know that I would do that today, but we're talking 1993. So I was pleased with the part of the opinion that recognized that marriage is between a man and a woman, and I was puzzled politically how we were going to deal with the other part. And the Reciprocal Beneficiaries Law had some benefits, but not all, and it was open to everybody. It was really marriage equality. Everybody that wasn't allowed to marry could become a reciprocal beneficiary. Fathers and daughters and moms and sons and all that stuff. It didn't have a sexuality aspect to it.
I can remember that period very, very well, because I can still remember writing a column in which I sort of said, this Supreme Court, when they're dealing with something this big, they shouldn't have had a 3-2 decision on this. This should have been something they'd worked out, and they'd have 5-0 decision, because it was so big. I criticized Levinson. I think I was such a bold columnist.
You must be pretty routinely disappointed in the United States Supreme Court.
I know.
Then.
On 5-4 decisions, yeah, I am. You bet I am, particularly on very important matters. But nonetheless, that 5 years after that, between there and the constitutional amendment, that was one where the legislature was just tied up in knots. Largely, it seemed to me, whenever I went down there, and largely it was over this debate, over same-sex marriage. And we were the first to come down with a decision like that, right, in the country? First state Supreme Court?
That's right. That's right. As far as I know, the first in the world.
No, I think Minnesota had one.
Minnesota dealt with that in 1970, 1971, Baker v. Nelson.
Baker v. Nelson was one of 4 state court lawsuits that went to the appellate level and resulted in published opinions. One was Baker. One came out of Pennsylvania, one came out of Kentucky, one came out of Washington State, and all 4 of those went the other way. So Bear v. Lewin, I think we all agree, was the first appellate decision ever to rule that a state's marriage laws were presumptively unconstitutional by virtue of not giving access to the status of marriage to same-sex couples.
But I'm sorry, go ahead.
Well, it's interesting. I mean, the status of marriage to same-sex couples do not hold rights. Individuals hold rights. And when we talk about marriage equality, I think it's actually more accurate marriage redefinition, because when anybody goes to the court in their county, they don't ask you what your sexual orientation is. They don't ask you what your story is. They don't care. Marriage, as it's defined, treats everybody equally. Now, same-sex couples do not want to marry under current law, so they have to redefine what marriage is in order to marry under it. I mean, so let's be honest and let's be clear.
I'm not quite sure I followed you, Glenn, when you say that same-sex couples don't want to marry under current law.
They don't.
What does that mean?
If any of us go to get married tomorrow and we show up and we say, I'd like to get married, the court doesn't ask us our sexual orientation, our sexual preferences, anything like that. They don't discriminate about individuals. All they care about is there a man or a woman? Okay? Same-sex couples don't want to marry under that sort of definition, right?
Well, we made that very point in Baird.
Right. And so we have to
that's why the term gay marriage is really a misnomer,
but no,
or heterosexual marriage is a misnomer.
But isn't the need then to redefine marriage? To say marriage is not necessarily about male and female. This is an issue of redefining marriage, and that's not a negative thing or a positive thing, but let's be honest about what we're talking about. It's about redefining marriage. It's not about marriage equality, because marriage, as it's defined under the law, allows anybody. But it's if you want to marry somebody of the same sex, whether I want to do that, anybody, you can't do that. You've got to change the definition of marriage. So let's be very clear that we are radically and permanently talking about redefining a fundamental human institution with really out any public debate on this subject.
We've had a fair amount of public debate in this state, Glenn. I don't know about Colorado, but we have here. Renea, I think you want to.
Yeah, no, I'm not an expert, and I don't pretend to know the laws as well as you gentlemen do. But what I can say to that is, I just remember in 1967, in our history, and correct me if I'm wrong, was Loving versus Virginia, when interracial marriage was not allowed in this country. And I mean, to me, that what you're saying then would apply then too.
Not at all, because see, Loving versus Virginia took marriage and used it for social reconstruction to keep the races apart. Marriage is about bringing men and women together. And Loving versus Virginia reaffirmed marriage that says that any man and any woman can get married and come together. See, that is what marriage does. Marriage is not about keeping...
That was the same exact argument.
That was a redefinition of marriage, wasn't it?
Yeah.
I mean,
not at all.
In 1949, 30 of the 48 American states defined marriage as a union between persons of the same race. Bear with me. Including your state, I might add, Colorado and California, and 28 others.
I'm actually from Hawaii.
I gather that you were born in Los Angeles, but we won't hold that against you. In any event, when the Virginia trial judge sentenced the Lovings to 25 years in prison for having the audacity to be married to one another and setting foot in the state of Virginia, suspending the 25 years of imprisonment on the condition that they leave the state of Virginia and never return, the court explained its reasoning this way. Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix. And so same race was an integral part of the definition of marriage in an overwhelming majority of the states in America.
But in fact,
until
the Loving
definition
couple
was redefined.
was a man and a woman. In Loving, it was a man and a woman, which would have been presumed, as it was in Hawaii, before your opinion made us change our statutes.
Those laws.
I
hear that quoted all the time. I mean, it really comes out of the talking points that, okay, there was this incredibly ignorant rationale for why we should hang on to these laws. And basically what that means is if something is argued for something in a horrible way, then we never should argue for it in a reasonable way, because some, really quite literally lunatics had this very crazy view of what would happen if we let people of different races. Loving was not about keeping the races apart. It was about black and white, and it was about white racial purity. And that, folks, was wrong. It was wrong on every level. But marriage is not about fundamentally keeping the races apart. It's about bringing men and women together.
Glenn,
and the Supreme Court supported
the trial
marriage.
Court at the time, Glenn, didn't know it was wrong.
And they were
the
wrong.
Interesting thing about crazy and ignorant thought processes or belief systems is that when they're in vogue, they aren't regarded as crazy or ignorant. This judge fervently believed that he knew what God intended and what God intended about marriage. And one of the central tenets that God held most dear was that married persons must not be of different races.
And
it's not marriage if
and
they
it's
are.
cited in the Loving decision because it's a ludicrous argument.
Glenn, let me interfere for a moment because I'm not sure that we're going to work this one out. And I'd like to turn to another aspect of it. Be that as it be, wherever we are on redefining, hasn't the culture and the society, Bear versus Lewin, was a landmark decision, and then the legislature had to deal with it, and then we end up with reciprocal benefits, I believe, and then now we have, as of the first of this year, civil unions. But doesn't the culture redefine things too? I mean, people feeling free about coming out and admitting their sexuality was something that was not as prevalent in 1993 as it was today, and we have now, I think, certainly among younger people, the acceptance of sexuality is much different. Mm-hmm. And aren't we redefining marriage? Aren't young people redefining marriage? I'm having trouble finding young people, any of them, heterosexual or homosexual, who want to get married as much as they used to. We've got, it's incredible. Living together for long periods and not, if they marry, having children. Is that a redefinition of marriage? Isn't that a redefinition? I'm seeing
heterosexuals redefined marriage first, and that was through no-fault divorce, basically saying that till death do us part of marriage really doesn't matter. And that turned out horribly. Ronald Reagan was the first governor in our nation to sign into law our first no-fault divorce law. That was a radical redefinition of what marriage is, and it has been an utter failure. The young people today don't say, "Oh, I'm so glad my parents had the right."
No, don't misunderstand me. I'm not making an argument that this is a horrible thing to have happened. I'm just saying that it's happened.
Right.
For good
some
or ill.
Some changes are good. Some changes are bad.
But it's happened, and a lot of young people, probably as well educated and sensitive as you and I, have made those kinds of decisions. Mm-hmm. And boy, you see it everywhere. And I don't know whether the redefinition argument whether that can take us anywhere.
Yeah.
We are in a different place now, 20 years.
But we have to ask the question: is the redefinition good? And the times that we have redefined family formation, that's the research that I do full time. When we redefine how families are formed, cohabitation, divorce, step families, things like that. Are they good things? Do they promote human well-being? Not just do they meet the desires of those particular adults, but do they serve the well-being of children? Do they make us better men and women? Do they strengthen the society? And none of the changes that we've seen up till now, whether it be divorce, single parenting, fatherlessness, cohabitation, none of those have served to help or improve human well-being, but diminish it significantly.
Renea, has same-sex marriage hurt the institution of marriage in your mind, or has been a bad thing?
Well, no, absolutely not. You know, I'm just an everyday person. I go to work every day. I pay my taxes. I have a mortgage. I just want to have equal protection for my family.
You're so everyday.
I am so ordinary, you know, and that's it. The institution of marriage. I mean, some of these arguments that you're saying are that, you know, the we can't have this happen, you know, marriage equality, and you don't want to call it marriage equality, but that's really what it is. You don't want to call it that because a brother will marry his sister, or this will happen, or that'll happen.
Marriage equality, it would.
I mean, polygamous individuals, they don't have marriage equality.
Right. But what I'm saying is, I just don't understand how you can say, you know, young gay men and women can serve this country, they can go to war, they can fight for their country, we can pay our taxes, but we don't get equal protection under the law. How is that fair, and how is that okay?
Polygamists could say the same thing.
I'm not a polygamist, so that's
and you know what? You don't have to be. But they are
we don't
making...
have to debate that either.
Right.
You know what?
Because the question that's before us is whether persons who are in a loving, committed relationship ought to be entitled to get married when they aren't, even though they are eligible in all respects, but for the fact that they are not an opposite-sex couple. Couple.
And that is one criteria for marriage that we're saying we should do away with that and we should let them get married. But all the arguments that you just made, you know what? We're hardworking citizens. We obey the law. We show up at work every day. There are other people that are seriously making those arguments, and there are lawyers, serious lawyers at Georgetown that are arguing for, if we're going to allow this kind of marriage, we should allow polygamists, law-abiding polygamists, good people who want to enter these kinds of relationships. We ought to allow them to marry. And the Prop 8 argument just a couple of months ago, they asked that question. They said, well, if we're going to allow this, what is the compelling factor that would make us prohibit polygamy? We're not arguing for polygamy, but it's the issue of, you're going to make the criteria of people should have equal access to marriage and marriage equality, then we have to say, okay, who gets excluded from that and why?
At this point, we're really debating the number of angels dancing on the head of a pin. The fact is that in 2011, the Hawaii legislature enacted a civil union law that afforded to eligible same-sex couples, consisting generically of couples who would satisfy all of the requirements, prerequisites for marriage under the current law, but for the fact that they are same-sex couples, the status of civil union. Attached to the status of civil union were all of the rights and benefits and duties and obligations that the state of Hawaii confers on married people. And so the question that's facing people in Hawaii is why it is then that those same-sex couples who have been given all of the rights of marriage, including child rearing, should not be able to marry. The fact is that a lot of water has passed under the bridge since the Bear v. Lewin decision came down in 1993.
But Steve,
and in the United States, now, today, in Massachusetts, Connecticut, Vermont, New Hampshire, Maine, Maryland, Rhode Island, New York, Iowa, Washington, and the District of Columbia, same-sex couples may marry. California, I predict, will be back in the same-sex marriage column as of June. We can talk about that later. Delaware is coming. Illinois is coming. Nevada is coming. Minnesota is coming. Oregon is coming, and Hawaii is coming too. I think very likely at the beginning of next year. At the same time, virtually all of Western Europe, Argentina, South Africa, New Zealand, Brazil, Mexico, recognize same-sex marriage. We're beyond the point of theoretical discussion of what is ideal.
Steve.
Let me ask one quick question, Renee. Renee, why if as Justice Levinson just pointed out, the civil unions are giving to couples, why didn't you marry? Why don't you?
That's a good question.
I don't get it.
I mean, because we want the right to be married. We want to be married. We want to be treated with dignity. We don't want to be treated like second-class citizens.
But marriage isn't about what adults want. Marriage is
Marriage
about
is
what
a choice.
children need. That's what marriage is.
Well, what about the gentleman that's sitting to the right of me that remarried after his children were raised, after his wife had passed?
That's fine.
Should
that's
he
perfectly
not?
fine.
So he should be. But then your argument doesn't stand true.
It does, because when young people are in childbearing, it's the children that is the state's interest in marriage. It's what the kids need, not what the adults
But
want.
I heard a point earlier you make, and you said, the children, and it's about the kids, and I understand that. And quite frankly, I have friends who are gay, raising children, and really I believe, and I think most people would agree, that raising good children who become good contributors to society or a community is usually because you mentor them well, because you give them good fundamental values. It has nothing to do with your sexual orientation.
And it doesn't, but it does have to do with form of the family. You know what? Single moms love their kids. They're involved. Divorced parents, step-parents love their kids. But what we find out through the research, that when kids are being raised by somebody who is not either their biological or their adoptive mother and father, they face significant problems. And it's not because those homes lack love or commitment. It's the form of the family that really does matter. And the social sciences are very clear about that, and that's important. I think it's interesting what we were talking about earlier about the civil unions is, Steve, you said that the state passed that civil union law. Who was it that was pushing and advocating for that? It was the gay and lesbian community, I think.
That's correct. Making it clear, incidentally, that civil unions was a way station, that the end point was marriage. There was never any question about that.
They made it based on the argument that we need these legal benefits. We need these legal protections. The legal protections are there. The legal benefits are there. And I think there are a lot of couples like you, understandably, who say, you know what, it's not about the legal agreements or the legal responsibilities. It's about marriage itself. You know what?
There's 1,100 federal benefits were not given because of DOMA.
You know
when
what?
the states
not
start
1,100.
to, well, over 1,100.
They're responsibilities, and they're minor things. I mean, I've looked at that whole list.
So,
it's not.
We can agree that there are lots.
But
Social Security,
how about a slew?
death benefits.
I like the word slew.
But the point of, if these are life and death kind of things, that these couples need these, then why do we think it's a bad thing now that we gave them through civil unions? And that there are a lot of couples exactly like you and your partner who say, you know what, we are not going to avail ourselves of these things. We're going to wait till we have marriage. Well, when you're in a place where you really have needs, you avail yourself of the needs that are there. And I think it goes to the argument that I see a lot. It's not so much the needs themselves, it's about the symbolism of what marriage is. Because there's practically no difference between civil unions, what they do, and what marriage does.
But Glenn, but if you had been here 3 years ago, I guess the last time we got together to argue about this, about civil unions, you would oppose them too, right?
Civil unions?
Yeah.
Absolutely.
Well,
Absolutely.
so why not, let's just change the law and call it marriage.
Now leading gay advocates, I mean, I don't know any leading theorist on the other side who thinks civil unions are a good thing.
No, that's not true.
Who?
But
Can you name one? I mean,
I can't think of one
gay
who
or
doesn't.
lesbian advocate now on the scene.
The issue
who thinks
isn't whether civil
unions
unions are a bad thing. The issue is whether civil unions are enough. And you just identified the reason why the label is not enough. the status of
But her
marriage
community sees them as a
carries
bad thing.
tremendous symbolic significance.
Yeah, absolutely. So it's not about the stuff then.
Dignitary value, if you will. I mean, it's as
Fully
if,
agreed.
as a remedy to what you characterized as the ignorance of miscegenation laws, you know,
Or the defense of them.
anti-mixed race marriage laws, would have been to create a separate status. You know, for regular people, we'll have marriage. And for mixed race people, we'll create a new status and we'll call it interracial union. Well, that's absurd.
It is absurd. I completely
The reasoning
agree.
is the same. If same-sex relationships are given a status on the par with marriage in terms of access to rights and benefits, then there really is no theoretical justification for withholding the dignity and respect and social significance of the label marriage.
So you've just effectively made the case that it's not ultimately about the rights and benefits. It's about the name of marriage and the institution of marriage and the place of marriage.
Glenn, it's clearly about both. I'd like to get to back to a point that Jim made when he suggested that children are really the raison d'etre, the reason for existence of marriage. It reminds me of when my late wife and I went through the Marriage Encounter program in 1979, which I frankly cannot recommend too highly. I think it's great. And we went through the Episcopal expression here because they had the best program. And there was a session on child rearing and a lot of discussion about the problems that people were having raising their kids and the relationship with their kids and so on. And one of the facilitators of the weekend said, you know, marriage is the sacrament, not parenthood. Would you believe that until 1984, one of the statutory prerequisites to eligibility for marriage in Hawaii was procreational capacity? It was statutorily required that neither of the parties is impotent or physically incapable of entering into the marriage state. And the legislature amended the marriage law to delete the prerequisite of procreational capacity. And in doing it, the Senate Judiciary Committee wrote that the notion that the primary purpose in marrying is to bear children is a narrow and outdated view.
Well, Judge Kaye just last year ruled in the Jackson v. Abercrombie case. He granted Hawaii Family Forum, which I'm local counsel for, and the Department of Health motions for summary judgment that there is no U.S. constitutional right to same-sex marriage. He indicated that the state's interest in marriage is in heterosexual couples who can accidentally procreate. And to your point about the amount of nurture and stuff that gay parents put, hang on a minute, Steve, that the nurture and stuff that goes within gay families is because it wasn't accidental. They worked really hard in various different scientific ways, or they adopted or something like that. And Judge Kaye granted our motion, granted the state's motion, threw the case out, and it's on appeal.
That's Jackson v. Abercrombie.
I want to clarify one thing, Dan. What Judge Kaye ruled, because the issue before him in that respect was what was the standard of review of the Hawaii marriage statute for purposes of determining its constitutionality. And what he ruled was that the Hawaii legislature could theoretically, rationally, have made the value judgment that opposite-sex marriage served the state's interest in encouraging responsible procreation or child rearing. Whether or not the legislature actually believed that,
That's the rational
and whether
basis
or
test.
not the
In every court
legislature
case.
was correct if it actually believed that.
Let me make a little transition here. The Supreme Court is going to come down with some sort of decision on the Defense of Marriage Act in June, or you think it may be a little bit later than that.
And Prop 8.
And Prop 8. What we are in a position right now where we have civil unions. California's in limbo at the moment. What are the possibilities that can come out of DOMA that are going to change the ball game? I mean, Abercrombie versus that's stopped at the Ninth Circuit. Everybody's waiting for the Supreme Court. What's the Supreme Court going to mean in this? I mean, what are the possibilities?
You know, I listen to the pundits writing based on questions that justices ask in oral argument. They try to figure out what they're going to say, and it usually it's wrong. I mean, so I figure they can uphold it or they can throw it out.
The Defense of Marriage Act?
Yeah.
What's your guess? I'm looking for guesses. I went down and had lunch with 4 lawyers one day, almost certain that the Supreme Court was going to do one thing, and all of them said they were going to do something else.
Exactly
and they were
my
all
point.
right.
Yeah.
They were
Now,
all right.
There was a case, I don't know, 5-10 years ago at the U.S. Supreme Court. It was a Lopez case. And it dealt with Congress enacting a heightened criminal penalty for possession of a gun within so many feet of a school that gets public funds. And this Lopez guy got busted doing something bad with a gun within that geographic distance. And he challenged Congress's constitutional authority to regulate gun possession within a distance of a school. And the Lopez court, the U.S. Supreme Court, said there are a series of legal issues that are state concerns, not Congress's concerns. And among those is, they'd have this little litany of things, marriage. And when I saw that, when it came out, I thought to myself, wow, that's a little time bomb sitting there to throw everything back on the states. But because what happened with Roe v. Wade and those abortion cases through the Supreme Court, everybody thought it would be over and it wouldn't be an issue anymore. And this is how many years later, every January 20th or whatever it is, all across the country, people are up in arms about it.
It actually started the debate rather than...
Yeah, so
what do you think is going to happen?
I think Jim's really put his finger on what the most likely outcome of the DOMA case is, the Windsor case. I read the transcript of that oral argument very carefully and listened to it on audio. And as we all know, you never know what the United States Supreme Court is going to do, even when they seem to be tipping their hand. But I think there was a lot of hand tipping going on in that oral argument. And a lot of it came from Justice Kennedy, as so often happens.
He's the swing guy usually.
He's the swing guy often. I think that the most likely outcome is a majority, might be 5-4. It could be 6-3, but might be 5-4. Kennedy, likely the author of the opinion, holding that Section 3 of the Defense of Marriage Act, which creates this federal definition of marriage and withholds the federal rights and benefits of marriage from people who don't meet that definition, constitutes an illegal incursion into the exclusive prerogative of the states to define marriage, and that therefore DOMA violates principles of federalism and is unconstitutional. I also think it's...
Now, you agree with that?
Well, I think it's a possibility because the Lopez case is sitting out there.
Okay.
Sure.
And I would have to admit
Kennedy
that
expressly fretted out loud about how the federal government could be encroaching on the prerogative of the
But
state.
Steve, when you were on the Supreme Court in Hawaii, did you ask questions not because you wanted the answer, but because you wanted some co-justice to hear the answer?
So certainly.
Yeah, so that's why...
And that's the reason why we never know.
Yeah, exactly, exactly.
Okay, we have a few people watching us right now, and they have some questions
Nice
and
folks
comments,
at
and
home.
we must get to them. What about married couples who choose not to have kids? Does that mean they're not fulfilling the real reason for marriage?
Not in Hawaii. That was taken out.
That was taken out. You feel
But
they
they're
are.
the exception. They're the exception. The norm is for a man and woman to come together, and it is highly likely that they will have kids.
That's a norm in your opinion.
Well, no, it is a norm. I mean, it's just the facts out there. If you look at the numbers, most married couples at some point in their marriage bring forth children or adopt children in. I mean, it's just an empirical fact with the numbers. It is not the norm for same-sex couples. I mean,
Because we're not afforded the norm.
by biology, right?
No, you know what's interesting that I find whenever someone says they're opposed to being married or for same-sex couples, generally the argument is based on religion. And I just want to make
Not at
one
all.
point. No, I'm not saying you're saying that.
Yeah.
I just would like to, if you don't mind, Emmy, make one point. And that is that, you know, the freedom of religion, or what we have in this country, better known as separation of church and state, was created to give people the right to practice their religion freely. It was never meant to take people's rights away. It's just fundamentally wrong in this country, in this state, to actually create legislation or any bill that takes people's rights away.
So would you agree then that my client, who has a bed and breakfast in Hawaii Kai, that is a very devout Catholic woman. She and her husband are grandparents. They have their big 4-bedroom house that's empty. They rent 3 of the rooms out from time to time to people that want to live there. When she got a call and the lady identified herself as a lesbian and wanted to come sleep in the same bed with her girlfriend in my client's house, my client very politely said, you know, I'm a Christian. I'm really not comfortable with that. Can I refer you to my friend across the street? Actually has a nicer house than I do anyway. And that was in 2007. Since 2008, the Civil Rights Commission complaint was filed. That process took until 2011 when they were given a notice of right to sue my client. So now they sued my client in court when my client's religious beliefs with respect to the beds in her house should be protected, is what I think you're saying.
Well, it depends. She's running a business. There are certain laws and guidelines in running a business. So.
No, if there's actually a statute, Chapter 515 in Hawaii, that says if you're going to enter into real estate transactions, which renting those rooms are real estate transactions, and you live in the home where the rooms are and you rent 4 or fewer, you're completely exempt.
Hochberg?
Yes.
We're talking marriage here tonight. We're talking marriage,
Thank
not
you.
rental
I
agreements.
liked her.
I am a religious minister, this man says, who has married couples for 30 years, but because I'm gay, I can't get married. If heterosexuals only had civil unions and homosexuals could marry, heterosexuals would have a fit. It's not fair. Carl Myers on the Big Island. Tom and Hilo wonders if the Lewin v. Baer decision would have been the same if we had elected judges instead of appointed judges. What if they had had to face re-election? Judge.
You're asking me that?
Yes.
I think that elected judiciaries, and there are about 38 of them, 38 states elect their judges one way or another. It's one of the worst ideas that was ever implemented. The function of judges, at least with respect to enforcing the Bill of Rights, is precisely to be counter-majoritarian. Judges, by their very nature, are not supposed to do the popular thing. They're supposed to apply law to facts and reach the result that the law requires, in their view, whether they like it or not.
So would you
to answer
would you have still done?
To answer the question,
Yeah.
one of my first, I think it was the first time I attended a national forum for state appellate court judges. It was shortly after I went on the court. It might have been in 1993, after I'd authored the Baer v. Lewin opinion. I think it was. And I said, it's not a coincidence that that decision came out of Hawaii, a state where judges are not elected and don't have to suffer because the majority does not approve of decisions that they render. So I think it's very likely that if the Hawaii Supreme Court had been elected, and if it had, I can assure you I would not be on it, because I wouldn't have run for election. It's very likely that the court would not have had the guts to do what it did.
Edith from Eva says, I'm against couples of the same sex adopting children. It's not normal for mothers to sleep with mothers and for fathers to sleep with fathers. It would cause a hardship on the child. Are there any studies in this? Speak now or forever keep your peace.
That's a big question.
I would like to hear the opinion of the Native Hawaiian cultural practitioners. Please ask them to call in with their opinions. We only have about 5 minutes, so that's not going to work out very well. But if you would, we'll take them. Lorna and Wahewa are worried for how things would go if these rights become legal. Would others who refuse to marry them, rent to them, sell flowers for weddings, become lawbreakers if this becomes legal? This goes back to your question about where does it stop? Underage marriages, polygamy, incest.
What we need to realize is that there is a huge conflict between religious liberty and same-sex rights, because what's happening across the country is people who use their artistic talent to make flower arrangements or bake cakes or photography or wedding dresses. If they believe that marriage is really only a relationship between one man and one woman, and they have that religious perspective on marriage, and they don't want to lend their creative talent to a same-sex couple's ceremony, I think they should be protected. And it doesn't have anything to do with whether or not they're getting paid for their work, because people should be allowed to use their expressive talents in the way that they want under the First Amendment.
The First Amendment, freedom of religion, doesn't extend to that kind of discrimination, and it never has. I mean, suppose the same flower arranger believed that Jews, for example, were damned to perdition because they persistently refused to accept Jesus Christ as their Lord and Savior.
There's a single person in this country with that belief today.
And that has ever happened, that it's actually manifest itself. And you know, and I love the emotionalism of
Let me finish my
Yeah.
thought. I ask because I'm Jewish, obviously, you know, go talk to Morris Dees about the extent of anti-Semitism in the country before you dismiss it so blithely. But my point is this. I think it's intuitively obvious that no one in their right mind would argue that that person has the right to refuse to make flower arrangements for Jews if they're in the business of making flower arrangements.
And you know what? I mean, has that ever been a problem? The issue is, it's interesting that this whole...
Or black people.
But this whole thing operates under the banner of tolerance. Let's be tolerant of different people and where they are and what they believe, and let's make a community where we can tolerate different things. But there is not much tolerance for the nice couple who run this bed and breakfast. You know what? I don't agree with them, perhaps. You know, I mean, you can say, I don't agree with them, but I am not going to impose my beliefs, which this lesbian couple is doing, and saying, you have to see things my way. Rather than saying, you know what? I don't want to offend you. I don't want to bother you. I'm going to go across the street to another place.
But isn't it normal for when any of us are ever discriminated against for any reason, we protest? Do we not?
But the issue is, okay, you're fighting for marriage. We need marriage. We need marriage to feel equal. Okay? When you get marriage and somebody else doesn't agree with you, the nice couple who does a photography thing out of their home, that feeling, that essence of equality that marriage brings isn't enough, because we're going to demand that these people violate their own conscience and their own beliefs.
I think we can all agree that tolerance is a good thing, and that everyone ought to be tolerant.
And every single person I know that is gay, and myself included, would not want to use a business or a rabbi or a reverend or whomever to perform a ceremony that was not on board.
I would say I wish every same-sex couple were like you, because that's reasonable.
You are going to run into
thoughtful.
discrimination, though. My point is, just like Justice said, is you're going to run into it wherever you go.
Is there any consensus that's going to be reached in the country? And we're down to 1 minute. Is there any consensus? You get 15 seconds of it, Justice, no more. Is there any consensus that's going to be reached on this issue?
In the passage of time. I mean, sooner or later, just as as segregation was ultimately outlawed, and that became socially accepted, sooner or later.
I think that through Hawaii Family Advocates, if we are successful in electing people to the legislature, it won't be happening.
I believe our congressional delegates, as well as our great president, who supports marriage equality for same-sex couples, I believe that the legislature will fall in line and they will do the right thing and stand on the right side of social justice, just like Hawaii has always done.
This is absolutely not inevitable. That, Roe v. Wade, as you mentioned, I think very wisely, didn't settle the abortion question. It initiated the debate.
Glenn, thanks for coming so far. Sorry to cut you off, but you're last. Thank you all for being here. We could do another 3 hours on this. Today was the last day of the 2013 state legislative session. Some of you are breathing easily now. Our elected representatives considered a slew of bills and passed something less than a slew of them, covering everything from early education to labor agreements. We'll review the session with new leaders in the House and Senate from both parties and a member of the governor's legislative team. What passed and what went by the wayside, why, and how much will it all cost? That's next time on Insights on PBS Hawaii. I'm Dan Boylan. A hui hou.